Mention, the defense counsel made several prayers. Both the defense counsel and the prosecution made quite noble and elaborate submissions. The prayers regard the right of medical examination of the accused, enabling the accused to access their phones, IDs, passports, as well as ATM machines. The defense also prayed for expeditious conclusion of investigations by the prosecution, as well as affording the accused the right to access their relatives and friends at court. I've carefully considered the submissions of both the defense counsel and the prosecution. It's true that even when the accused are on remand in prison, they continue to enjoy and or are even entitled to various rights, including but not limited to the access to medical care attention. The accused ought to be examined, and if found to suffer any ailment, must be afforded medical attention by the state. In this case, the defense contends that the accused persons, save for A36 Sarah Apale, have never been medically examined to establish the torture they suffered. The prosecution, on the other hand, submitted that the accused were examined at arrest, and after being remanded, medical examination. The prosecution, on the other hand, submitted that the accused were examined at arrest and after being remanded. Medical examination can be easily proved by medical reports. If at all the accused were examined, medical reports can be produced in court and also be shared with the defense. I therefore direct the prosecution to produce in court proof of medical examination of all accused persons at the next mentioned date. Regarding the medical examination of Sarah Pare at Murago, this court was not provided with evidence constituting circumstances how Sarah Pare was taken to Murago for medical examination. However, if there was such examination, the prosecution should equally provide proof of the same in court at the next mentioned date. Accused should be allowed to access their IDs, passports, phones, and ATMs. The prosecution indicated that some of the documents are to be used as exhibits, while for the rest they were not aware of them. I'm aware that this is a matter whose investigations are still ongoing. However, the accused have a right to ownership of personal property. I therefore direct the prosecution to specify which items are to be used as exhibits. If there are those that are not going to be used as exhibits, including the phones, ATMs, passports, IDs, the same should be handed over to the respective owners as soon as practically possible. And for avoidance of doubt, I hereby direct the prosecution to furnish court with a detailed report regarding the aforementioned items at the next mentioned date without fail. The defense also applied for swift disposal of the inquiries and investigations. The prosecution indicated how the process is quite complex, however, that they are doing all possible as the Office of Director of Public Prosecutions to conclude investigations in time. The right to a fair hearing includes the right to a fair hearing, entails swift conclusion of inquiries and committing the accused for trial if necessary, like in this case. I'm aware that the Office of the Director of Public Prosecutions is an independent institution charged with the duty of charging, investigating, and prosecuting cases like the one in this case. I, however, implore the prosecution to be mindful of the accused's innocence until proven guilty and the right to liberty. In so doing, the prosecution is hereby implored to swiftly investigate and conclude the process, being mindful of the accused's rights.
Richard from Boka, Chief State Attorney for Prosecution. The accused persons are in court, all represented by Turinawe Bayan. We have Akio Tumusime. We have Philip Munari. That project is standing. Where is it? He's squeezing himself down where this is. This matter was coming up for further mention. The inquiries in this matter are not yet complete. Reason being that The accused persons were arrested from Kenya and the process of retrieving some of the evidence requires a process known as the mutual legal assistance, which is a little bit complex.
It requires what?
Mutual legal assistance.
Yes.
A process which is a bit complex and different from the normal ways of acquiring evidence. In effect, it's not a one-day affair, so it will take some process and time, for which we seek but it has been our submission that it is our obligation as a prosecution to ensure that these inquiries are complete as fast as possible to ensure an expeditious trial of the accused persons and also, on the other hand, uphold their right to a quick judicial process.
Obtaining evidence requires more time. From the 28th of July 2024, when they were first arraigned. Not to mention how the state was quick to arrest without the evidence. But Your Worship, we find that there are more pressing matters in this case. The court should make orders on, such as the prayers which formally made on report. But further, Your Worship, among the accused is a girl or a woman called Sarah Apale, who was tortured gravely within the arrest. Your Worship, Apale Sarah sought medical attention on remand, but what is strange, Your Worship, is that the examining doctor has refused or failed to make a report as to the examination. Your Worship, such a report would be important both to examine the legal remedies available to the accused, but also to examine her present health condition arising out of abuse of her human rights by the state. Your Worship, she was examined from Love Hospital and she can only remember Brian as the name of the examining doctor. But with the order, Your Worship, we can still seek to find out who is that examining doctor. Your Worship, it is our prayer that the examining doctor makes the report available to our legal counsel, or in the alternative, she's granted access to a private medical doctor to make such examination as required. Accused persons have brought it to our attention that during the arrest, most, if not all, lost their ATMs to confiscation by the police, specifically at Nagarama police station. Your Worship, we make note of the fact that school term has begun, and for some it's beginning. Some of their children need to go to school and they need to access basic requirements. And for the fact that they are on remand, they cannot walk into a bank to make a withdrawal off the counter. And therefore we pray that the ATMs of the accused persons in custody of the state be released to their legal counsel, who will in turn provide them to their families for them to receive. Furthermore, is that it has been brought to our attention that the accused persons lost most of their gadgets, and specifically phones, to confiscation of the state. Your Worship, I will not address the matter of laptops, but I will address specifically the matter of phones, which are being misused by the state to call various people in their contacts. And in Worship, that is as far as we know. It is also possible that they are using them for other purposes, such as fabrication of evidence to this trumped up charge of terrorism. Your Worship, we pray that the court makes an order that the phones of the accused be returned to their relatives, or in the alternative, that at least they are kept in safe custody without switching them on and off as they are currently doing. The last session we held, or we had at this court, the accused persons were not granted a right to visitation on court premises, which is something that this court granted a right to visitation on court premises by their relatives that come to court, which is something that court stories allow, that to the extent that they are remanded to a prison such as Chitalia with the inconvenience to access them, their relatives at least access that right to see them. when they are on court premises. The court makes an order that the accused access their relatives or access the right to visitation from their relatives. And the magistrate stated that the rightful magistrate to give orders on those prayers was on leave. Your Worship, to the extent that we have come to sit in, we believe and strongly believe that since these that have been raised are urgent matters that concern rights and that concern the welfare of the accused, and their dependent relatives, we pray that you see it fit to make such orders as you deem fit in the circumstances.
Even having brought it to the attention of the superiors of Chitalia, to date, I have never been given any response as to why medical examination even having brought the need for the medical attention being brought before the superiors in Chitalia, they have never been given any reason as to why the medical examination has been made on them, ascertain the nature and extent of the torture extended to them, in your worship, when they are accused and on remand, they have the right to enjoy certain liberties.
On the essence of liberty as a pinnacle of justice, freedom, and democracy for the accused. Your Worship, echoing the words of former Principal Judge Justice Ogola in criminal miscellaneous application, has the machinery to investigate, detect, find, arrest, and return them for prosecution. My prayer, Your Worship, is that court issues an order that by the next adjournment, State has already obtained the mutual legal agreement to have this matter prosecuted.
This is a process through which one state obtains evidence or information from another state. Where an offense was committed from that state, or it was committed from its own territory but escalated to another state, to that particular state. You cannot simply wake up one morning and you get what you want. It is a process which is ongoing. And Your Worship, the Office of the Director of Public Prosecutions is an independent entity that no one can wake up in the morning, prevail over and say we want this to be complete tomorrow, because we are really working within the timelines. We are within the timelines. This matter, as a matter of fact, prosecution has 6 months within which it has to conduct its investigations. That's the grace period. And we have been submitting and emphasizing that we do not want to reach that period or to finish up the 6 months. But my brother was submitting as if the accused persons or prosecution has held the accused persons past 6 months. Expeditious process in this matter. And as I've been submitting, Your Worship, we are going to try our level best to ensure that the process is as fast as possible. I think we are not aware about that, but also I suppose it was a premature kind of application, because you cannot be seen submit on something you're not aware about. You don't have full facts. Court is all about facts and evidence. If you do not know the medical officer who examined, then how do you expect court to act? Court is not supernatural. So what I expected from my learned brother was to mention that this was the doctor who actually examined a body. Were subjected to examination before they were remanded. They were subjected to police form 24. As if that's not enough, all of them were subject to medical examination upon admission in the prison. Now, when my brothers talk about medical, we appreciate it is a right. It's something that we need to uphold. No one disputes it. But if someone was examined upon admission and was found proper, then what would be the reason for another medical examination if they have not moved it? Because there is no proof that they moved or they asked for medical examination and the permission was not granted. And if at all, if we are to believe that Aparisara was examined from Mulago Hospital, as my brother alleges, then how come she was taken to Mulago Hospital? That shows that this application is in bad faith. The submissions are in bad faith. Yes. In the first place, Your Worship, the accused persons have appeared here. I think this is the third or fourth time. The only issue that was raised by my senior colleague, I respect, the Lord Mayor, was the issue of the identity cards. It therefore perplexes NSN person where these applications are brought in bits, because we believe that if there was anything that was lost, then all those things should have been brought up in the first place and at once, not in bits. So Were they in custody of these ATM cards when Lord Mayor informed the court that their ATM cards had been confiscated by security? If this submission is right, I believe that if the ATM cards had been taken, as it is alleged from Nagarama police station, then even that time when Lord Mayor made this application, they did not have those ATM cards. And if they never had them, then why did they raise it? I am not saying that it is not true. What I'm saying is we have just been ambushed. I'll try to find out about this, but it raises suspicion. Something new.
Entitled to access to their relatives, including friends while in custody. This could be at court, prison, or any examination reports and serve the defense, perhaps before we come to court, so that we don't get. You told us that they were examined before at arrest and so is it possible that you can afford this to
fenga aba defense ffe nga aba defense oba abawolereza b'abantu bano endowooza yaffe tugamba nti buli w'okozesa essimu y'omuntu ono osobola n'okujingirira obujulizi.
Checho. Amanya nze katoto msimu. Emateeka waffe wano mu Kawaira 26 ewa buli muntu olukusa okubaako ebintu bye yeefunira nga ye right own property. Ate ATM zino embeera y'abantu bano mu byobulamu si nnungi n'akamu. Era mu kusaba kwaffe olunaku lwayo mu kooti tusabye kooti eragire state n'abakulira ekkomera ly'ekitalya abantu bano balina okufuna obujjanjabi Katutu Msime here, one of yes, it is true that state made it clear before this honorable court that these people were arrested in Kenya, which is not Uganda, and there are procedures. Mu Luganda state egambye nti eina okukanyako koyagala okutuukako ne ggwanga ly'e Kenya. Mujjukira bulungi nti bano abantu babakwatira mu ggwanga